the Honorable Chief Justice Martha Koome, Honorable Judges, my colleague judges of the Moot Court, our MTAs, our support staff, ladies and gentlemen, good morning. May I take this opportunity to welcome each one of you to the Supreme Court of Kenya, and also welcome you to the Supreme Court Moot Court Competition Finals. We have our bench that is led by the Honorable Chief Justice. I will hand over to the Chief Justice to introduce the bench and kick off the proceedings. Thank you.
Registrar of the Supreme Court, my lords, my ladies, learned counsel, all the participants, those present here in court, and those joining us online, good morning. Before us is one of the very consequential cases coming for hearing, the Nyota Refugee Coalition versus the Minister for Home, Land and Security, Department of Refugee Services. On the bench to hear the case is the Honorable Lady Justice Kauto Poru, the Honorable Lady Justice Torres, the Honorable Lady Justice de Klerk, the Honorable Mr. Justice Ouko, the Honorable Mr. Justice Renola, and myself, Martha Koome, as the Chief Justice and the President of the Court. I will request the court assistants to call out the cases for the parties to introduce themselves. We have allocated time to the appellants to share among themselves the 45 minutes. You can call out the case.
Your Lordships, Your Ladyships, greetings. My name is Cyrus Karaoke, appearing for the appellants. I am joined by my co-counsels, Ms. Nerea Akinyi Opio and Mr. James Kenyakisa. Before I begin, honorable members of the bench, I must acknowledge what an honor and privilege it is. Much obliged.
Honorable Chief Justice and President of this court, my lords and ladies, may it please this honorable court, good morning. My name is Tracy Jerop, appearing as the lead counsel for the respondents. With me today are my colleagues and friends, Mr. Liberty Mshindi and Ms. Ashley Ngeno. Thank you.
Counsel for the appellant, you can take the floor. You have your 45 minutes.
May it please the court, as earlier introduced, my name is Cyrus Karaoke, the lead counsel appearing for the appellants. I am joined by my co-counsels, Ms. Nerea Akinyi Opio and Mr. James Kenyakisa. Together we are team SC 016. We intend to use the 45 minutes allocated to us as follows. I'll be using the first 15 minutes to canvass our client's position as it regards the first and the second issue. My co-counsel, Ms. Nerea, will be using 15 minutes to dispense with the merits of the third issue. And finally, Mr. James Kenyakisa will be using 15 minutes to address the merits of the fourth issue. With the court's permission, I'd like to proceed. Before proceeding to our substantive argument, members of the bench, I must indeed acknowledge what an honor and privilege it is to be submitting before such an esteemed panelist of judges. It is indeed an honor of my life. With that being said, I wish to proceed to the merits of the case. Members of the bench, at a time when the Zypherian refugees have been confronted by mass persecution, enforced disappearances, sexual violence targeting women and girls, and ethnic persecution, the respondents have gone on to do the unthinkable. Not only have they trampled on the refugee rights of the Zypherians, they have also done so with the slightest of remorse. This, we submit, is repugnant to justice and morality. Turning to the first issue, we indeed assert before this honorable court that the use of artificial intelligence in refugee status determination violates the rights under Article 47, Article 50 of the Constitution of Nyota, as well as international refugee law. This position will be canvassed in one head of argument to demonstrate to this court that the aforementioned provisions were indeed violated. Turning to the right under Article 47, Article 47, sub-article 1 of the Constitution of Nyota, as read together with Section 4, subsection 1 of the Fair Administrative Action Act of Nyota, provides that everyone has the right to a fair administrative action that is lawful, reasonable, efficient, expeditious, and procedurally fair. The question then begs, members of the bench, how does the artificial intelligence in refugee status determination, how does it violate Article 47? We submit it does so in one way. It lacks sufficient human oversight. Human oversight, members of the bench, is a legal obligation created under Section 12 of the Refugee Act of Nyota, as read together with Regulation 9 and Regulation 10 of the General Refugee Regulations of Nyota, which states that an examiner for refugee status is to invite an applicant for an interview. During the interview, the applicant is supposed to present oral as well as documentary evidence in support of his claim. Pursuant to paragraph 9 of the fact pattern, members of the bench, you will be kind enough to turn with me. You will notice that the refugee status assessment was only conducted by the artificial intelligence refugee status determination. Members of the bench, your lordships and your ladyships, paragraph 196 of the United Nations High Commissioner for Refugees Handbook on Procedures and Criteria for Refugee Status Determination places an emphasis on human oversight in the context of refugee status determination, stating that it is up to the examiner to ascertain the facts that are being relied on to render a refugee status determination decision, members of the bench. Pursuant to paragraph 9 of the fact pattern, you will indeed notice that the respondent did not take any efforts to ascertain the facts that were being relied on to make the decision. The facts stated that Warido and his family belonged to a terrorist organization, when in fact, members of the bench, under paragraph 4 of the fact pattern, if you'll be kind enough to move with me, you will notice that Warido and his family merely belonged to an opposition political party which had been termed as a terrorist organization for simply opposing the government of Zypheria, which had refused to cede power, your ladyships and your lordship. And for that opposition, they were termed as a terrorist organization. If there was indeed human oversight, these flawed facts would not have resulted, members of the bench. We further place reliance on the case of Communications Commission of Kenya versus Royal Media Services, decided before this Honorable Court in 2014, where under paragraph 369 of the case, the court indeed acknowledged that administrative bodies are granted regulatory discretion with regard to how they perform their functions, provided they do so lawfully and non-arbitrarily. We submit that the discretion that was exercised by the Department of Immigration Services was unlawful because it failed to adhere to Section 12 of the Refugee Act as well as Regulation 9 and 10 of the General Refugee Regulations. Furthermore, in Mumo Matemu versus Trusted Society of Human Rights Alliance, decided before this Honorable Court in 2014, the court was careful to note that due process and accountability must be respected in administrative decisions, honorable members of the bench. Turning to the right to a fair hearing and how it was violated, the said right is provided for under Article 50, Sub-Article 1 of the Constitution of Nyota. It provides that every person has the right to a fair hearing before any impartial tribunal or court. The question then begs, how does the use of artificial intelligence in refugee status determination violate the right to a fair hearing? And for that, I wish to place reliance on paragraph 9 of the fact pattern and paragraph 10 of the fact pattern. Your lordships, your ladyships, pursuant to the fact patterns I've mentioned, you will notice that immediately Warido and his family were assessed for refugee status, they were subsequently detained. It is stated further that the facilities in which they were detained were inhumane, they lacked, or rather they were fully automated, and there was limited communication in those facilities. These circumstances, honorable members of the bench, frustrate the right to a fair hearing. And I will emphasize, the right to a fair hearing is non-derogable, and this is pursuant to Article 25 of the Constitution of Nyota. Therefore, any slight limitation on the part of the Republic of Nyota is indeed inexcusable before this honorable court. We further place reliance on the case of Gladys Bose-Sholei versus the Judicial Service Commission and another, decided before this honorable court in 2017, where the court noted that the failure of the Judicial Service Commission to give written reasons as to the dismissal of Honorable Bose-Sholei constituted a breach of the right to a fair hearing. Furthermore, Section 4.2 of the Fair Administrative Action Act provides that when an administrative action is to be taken against a person, then written reasons should be given to that person. A further reading of the same Section 4.2 provides that when an administrative action is likely to have adverse effect on the fundamental rights or freedoms of a person, then a notice as to an appeal or review mechanism should be given to that person. Members of the bench, kindly turn with paragraph 9 of the fact pattern, where you will notice that immediately Warido and his family were assessed for refugee status, they were subsequently detained. Therefore, they were not given reasons, and they were not given a notice as to an appeal or review mechanism. The right to a fair hearing, members of the bench, also needs to adhere to the principles of natural justice, which one of them is legal representation. Pursuant to the paragraph I have stated, you will notice that the conditions in those facilities could have frustrated Warido's right to seek legal representation, and we therefore submit the right to a fair hearing was indeed violated. Allow me to also place reliance on international jurisprudence, particularly MSS versus Belgium and Greece, decided before the European Court of Human Rights in 2011, where under paragraph 286 to 293, the European Court of Human Rights indeed acknowledged that an administrative action, especially in the context of refugee rights, that fails to adhere to procedure likely violates the right to a fair hearing. I wish to move on to my second issue presented before this honorable court. The second issue is whether the deportation order for Warido and his family violated the principle of non-refoulement. We indeed assert that it did. This position will be canvassed in one head of argument to indeed demonstrate to this court that the principle of non-refoulement was violated and that the deportation order for Warido and his family was not proportionate. Your Lordships, your Ladyships, the principle of non-refoulement is a cornerstone in international refugee law. It is recognized under Article 33, Sub-Article 1 of the 1951 United Nations Refugee Convention, as read together with Article 2, Sub-Article 3 of the Organization of African Unity Refugee Convention, as well as Section 29(1) of the Refugee Act of Nyota. It places an obligation on states not to return asylum seekers back to their states if they risk persecution owing to their race, religion, nationality, political opinion, or simply belonging to a particular social group. If you turn with me to paragraph 4 of the fact pattern, you will indeed acknowledge and agree with me, honorable members of the bench, that these requirements have been met by Warido because he is a member of a particular social group, which is the Democratic Liberation Party, and for this reason he was persecuted. Members of the bench, the principle of non-refoulement has also attained the status of customary international law, having fulfilled the two requirements of state practice and opinion juris. Members of the bench, we also acknowledge that the principle of non-refoulement, as the respondent will try to substantiate before this court, is not absolute and may be limited by law. And this is pursuant to Article 33, Sub-Article 2 of the Refugee Convention, which states that in instances of national security, then the said principle may be limited. We, however, submit that for the limitation to be lawful, it needs to adhere to the three-part test to the limitation of fundamental rights and freedoms as envisioned under Article 24 of the Constitution of Nyota, as well as Article 4, Sub-Article 1 of the International Covenant on Civil and Political Rights, as read together with the Syracuse Principle on the Derogation of Rights. The three-part test includes legality, necessity, and proportionality. We do not wish to contest legality and necessity. However, we have a bone to chew with the respondents with regards to proportionality. In considering proportionality, members of the bench, allow me to rely on the case of Kandie versus Alassane Ba, decided before this honorable court in 2017, where under paragraph 63 of the case, the court indeed acknowledged that the limitation of any right, honorable members of the bench, leads to adhere to the least restrictive means. If the least restrictive means is employed, then the proportionality test we submit will be deemed to have been met. The question then begs, was the least restrictive means adhered to? We submit it was not. Kindly turn with me to paragraph 3 and 4 of the fact patterns, your Ladyships and your Lordships, where you will notice that the civil war in Zypheria has been characterized by mass persecution, enforced disappearances, sexual violence targeting women and girls, political repression, as well as ethnic persecution. Furthermore, we also see under the aforementioned paragraphs that Warido and his family have suffered these forms of persecution. They have been held incommunicado and they have been tortured, members of the bench. The respondents took all these circumstances into account and decided that deportation was the least restrictive means. We submit it was not. We submit that the government of Nyota should have employed another least restrictive means, and for this we wish to place reliance on the International Detention Coalition Captured Childhood Report under Chapter 6, where it proposes that when the principle of non-refoulement and national security are at play, then the states should consider deporting, or rather taking the people who are being refouled to another region or to another state where they are not a threat to the national security of that state. We submit that the state of Nyota should have indeed considered that. Members of the bench, I have come to the end of our submissions as they regard the first and the second issue. And I invite my co-counsel, Ms. Nerea, to come and demonstrate to this court, which she will indeed do, that the best interests of the child were violated. I therefore cede the floor to my co-counsel, Ms. Nerea. Much obliged.
May it please this court. Greetings. As previously introduced, my name is Nerea Kinyopio, second counsel appearing on behalf of the appellants, and the 15 minutes graciously allocated to us by this honorable court will be used to address the third issue, where it is our position that the failure to conduct the best interest assessment for Warriors children violated Article 53, Sub-Article 2 of the Constitution and the United Nations High Commission on Refugees guidelines. Your ladyships and your lordships, this case is not just a case about missed procedure. It's about children caught between conflict and bureaucracy. Warriors children escaped a civil war, seeking safety, but yet instead they were reduced into data within an algorithm, detained, and are going to be deported back to danger. The appellant will substantiate their position using the following limbs of argument. On our first limb of argument, we submit before this honorable court that the Republic of Nyota had an obligation to conduct an individual risk assessment. Article 53, Sub-Article 2 of the Constitution mandates that in all matters concerning the child, their best interest shall be paramount. This duty is also featured in Section 8, Subsection 2 of the Children's Act, Article 3, Sub-Article 1 of the Convention on Rights of a Child, and Article 4, Sub-Article 1 of the African Charter on Rights and Welfare of the Child. In addition to this, the Convention on Rights of a Child, General Comment Number 6 of 2005, in paragraph 74 reiterates that states should give utmost attention to child-specific forms of manifestation of persecution, including sexual violence and recruitment into armed groups. Your ladyships and your lordships, kindly move with me to paragraph 3 of the case facts. In paragraph 3 of the case facts, we see Warriors children are experiencing these same forms of manifestation of persecution, including sexual violence. Therefore, the Republic of Nyota's decision to return them back to danger violated the obligation under the Convention on Rights of a Child. The respondents may submit before this honorable court that the artificial intelligence refugee status determination conducted the best interest assessment for Warriors children, taking into account family unity, which is a fundamental factor when it comes to determining the best interest of the child. However, seeing that there is no jurisprudence on this particular issue before this honorable court, the appellant would like to persuasively rely on the Refugee Consortium of Kenya case versus Attorney General in the year of 2015 before the High Court in paragraph 19 of the judgment, where the High Court stated that family unity is only viable if the state provides proof of existence and adequacy of children facilities. Your ladyships and your lordships, kindly move with me to paragraph 9 and paragraph 10 of the case facts. In these paragraphs, it is clear that there are only two facilities: the Government Automated Processing Center and the Nyairo Refugee Holding Center. Both these facilities were determined by the United Nations High Commission on Refugees as inhumane and unsuitable for children. In paragraph 20 of the judgment of the Refugee Consortium of Kenya case, goes further on to state that in order to determine the best interest of the child, an individualized, clear, comprehensive examination of the real-life situations of these children has to be made. Your ladyships and your lordships, kindly move with me again to paragraph 3 of the case facts. In paragraph 3 of the case facts, we see that these children are experiencing a civil war. This made it imperative for the Republic of Nyota to conduct an individual risk assessment, and their failure to do so violated both their domestic and international obligation. On to our second limb of argument, where we submit before this honorable court that the holding at Nyairo Refugee and Holding Center and the Government Automated Processing Center was unlawful. Your ladyships and your lordships, kindly move with me to paragraph 9 of the case facts. In paragraph 9 of the case facts, we see Warido's children were detained in a Government Automated Processing Center, a facility that the United Nations High Commissioner for Refugees deemed to be inhumane. Your ladyships and your lordships also move with me again to paragraph 10 of the case facts. In paragraph 10 of the case facts, we see that in August 2021, Warido together with his family were held at Nyairo Refugee and Holding Center, a facility that the United Nations High Commission on Refugees deemed to be unsuitable for children. In addition to that, in paragraph 9 and paragraph 10 of the case facts, we see that the holding and the detaining within these facilities, the children were not separated from adults. This is a clear violation of Article 53, Subarticle 1F, Roman 2 of the Constitution of Nyota, that states when children are being held, they should be held separately from adults. It is also a violation of the Refugee Children Guidelines on Protection and Care in paragraph 4 that states when children are being held, they should be held in humane conditions and a best interest assessment should be conducted. We rely persuasively in the case of POO versus the Director of Public Prosecutions before this honorable court in the year of 2017 in paragraph 44 of the judgment, where this honorable court stated that it is not of the best interest of the child to be held together with adults, as this may lead to a bruise that they will endure for their whole life. Honorable members of the bench, we therefore submit before this honorable court that the actions of the Republic of Nyota violated both domestic and international law. In conclusion, we submit before this honorable court and urge this honorable court not to let Warido's children be treated as files within a system, but as lives that demand safeguarding. We also seek this honorable court to come up with a declaratory relief affirming that in all matters concerning a child, their best interest shall be paramount. We urge this honorable court to come up with a verdict that favors the appellant side, and it's an honor to stand before this honorable court, and we're very grateful for this opportunity. I would like now to cede the floor to my co-counsel who will address the last issue and state our prayers. Much obliged.
May it please this court. Greetings, members of the bench. As earlier introduced by my co-counsels, I'm Counsel James Kenyakisa, last counsel appearing on behalf of the appellants. I intend to use 15 minutes of this court's time to address and canvass our client's position on merits of issue D. We stand before you today because the Court of Appeal erred in treating measures of administrative convenience as if they were constitutional necessities. In doing so, it allowed the state to do what the Constitution outrightly forbids, to reduce human beings into numbers already processed by machines and locked behind automated gates. The questions, therefore, your ladyships and your lordship, is the limits of state powers in times of a crisis, and whether national security can be achieved without limiting dignity, security, and freedom of movement that define our constitutional order. We intend, therefore, to submit that the Court of Appeal erred as such. On to our first limb, members of the bench, we submit that the encampment order violated human dignity. Article 28 of the Constitution of Nyota guarantees dignity as inherent and inborn. Further, we wish to place reliance on this court's judgment in Mutual Welfare Association versus Kenya Airports Authority in 2021, where the court stated that forced relocation that strips individuals of shelter, basic humanity and decency violates the basic requirements of dignity. Members of the bench, it is incumbent upon the state to ensure it protects fulfill rights of all individuals in accordance with Article 21 of the Constitution. And as such, members of the bench, we submit the conduct of the state blatantly disregarded these provisions. I wish to guide this bench to paragraph 9 and 10 of the fact sheet. We can see that individuals have been subjected to conditions that have been reported to be inhumane. These conditions are also reported by the UNHCR to be vulnerable for children and vulnerable people. Members of the bench, that we submit is repugnant to justice and morality. Further, members of the bench, we wish to submit in reliance to Article 1 of the OAU Convention, the Refugee Convention of 1951, that requires humane reception and respect to family life. We submit, members of the bench, unsanitary conditions, overcrowding, and such related conduct that these individuals have been subjected inside the camp does not in any way fulfill these obligations. Further, members of the bench, you stated in 2017 in the case of Francis Karioko Muratetu versus Republic to state that dignity is a source of all rights. It can therefore not be sacrificed on the altar of administrative convenience. Members of the bench, to reduce human beings to security liabilities and not see them to be enjoying individual rights as other individuals within Nyota is a blatant disregard to our constitutional order, and this court should not bless any invitation from the respondent citing national security, as we will substantiate limitations under Article 24 in our final limb of argument. Further, members of the bench, we wish to place reliance on Section 6(1) of the Refugee Act of Nyota that ensures that the state respects dignity of women and vulnerable people. Members of the bench, we can see paragraph 9 and 10 of the fact sheets. The conditions have been reported to be inhumane for vulnerable individuals. Such as well is disregard to Section 6(1) of the Refugee Act of Nyota. Members of the bench, as such, we submit that even Article 43 that emanates and also one of the pillars that is related to Article 28 of the Constitution has been violated. The respondent may cite that there has been an influx of refugees into our state that led to the strain of their capacity, members of the bench. But we do wish to submit that progressive realization, as they may submit, requires the state to take deliberate steps and not to sit there and do nothing. The state has to be seen taking important steps to ensure they realize these steps. We wish to place reliance further on Satros Ayuma versus Kenya Railways Authority, where the court stated that resource constraints cannot be used as a defense to indignity. Members of the bench, the Constitution requires compassion and not excuses. We further submit, members of the bench, the requirement under Article 43 that the state need to be taking reasonable steps does not give the respondent a carte blanche mechanism to ensure they sit there and postpone the achievement of these rights. They have to ensure, members of the bench, they take reasonable steps towards realization of the rights of these individuals. Further, members of the bench, we rest that limb of argument and move this bench attention to the second limb of argument, where it is our submission that the order was discriminatory and failed the equality guarantee. This is a cornerstone in our Constitution, our domestic law, and even international provision. It is our submission that Article 27 of the Constitution forbids the state from imposing measures that disproportionately targets a particular group. And our submission, therefore, members of the bench, the state has to ensure that the measures they put into place do not amount to exclusion or disadvantage. We wish to direct this bench attention to the history of the jurisprudence of this court in Peter K. Waweru versus Republic in 2006, where the court substantiated the meaning of indirect discrimination, to note that a failure to treat all individuals equally, where there cannot be reasonable distinction between those not being favored and those being favored, is what amounts to discrimination, members of the bench. Therefore, the state has to strike a delicate balance between a distinction that balances all these rights. And we submit, members of the bench, exclusion and disadvantage that these individuals have been subjected to inside the camp in Nyairo amounts to indirect discrimination. As this court was of the opinion in Mohammed Fugicha versus Methodist Church in Kenya, where it stated that even if there is a positive intent to limit particular rights, where the effect is a disadvantage or exclusion, such amounts to discrimination. Members of the bench, it is our submission, therefore, that paragraph 12 of the fact sheet shows that the order was only applied to Zephyrians, and individuals under our state continue to enjoy the particular rights guaranteed to everyone under our constitution. We submit that is repugnant to justice and morality. Members of the bench, you cannot chase a fly with a hammer. You will end up breaking the table. The individuals at the state has done the unthinkable. It has gone ahead to chase the individual's right, that is the guise of national security, with a hammer, and we submit that is going over and beyond what is within the limitations of the state under Article 24 of the Constitution. We place reliance on the case of Mohammed Fugicha father, where the court stated that the state has to ensure the measures it provides are within the reasonable dimension, and we do wish to substantiate that on our last limb of argument, where it is our submission that the restriction on movement was neither reasonable, necessary, nor proportionate. Article 39 of the Constitution guarantees freedom of movement. Further, the Court of Appeal, in the case of Kituo cha Sheria, in the case of Attorney General versus Kituo cha Sheria in 2017, noted that refugees as other individuals enjoy similar constitutional protection under the Constitution, and that such interpretation has to be done in a manner that holistically maintains the jurisprudence of this court. Members of the bench, for them to limit this right, they have to ensure that they limit themselves within the scope of Article 24 of the Constitution of Nyota. This court, further, in the case of Karen Njeru Kandie versus Alassane Ba, the Supreme Court petition number 2 of 2015, noted under paragraph 78 of the judgment that before applying the reasonable and justifiable test, therefore, a court has to ensure that the right it limits is under a particular law. It has to ensure that it is important for it to note the factors within the Constitution that lead to the limiting of that right, and that includes the nature of the right, the importance and the extent towards the limitation of that right, and the need to ensure that the fact that the enjoyment of rights of other individuals does not in any way prejudice the enjoyment of rights of other individuals. To that, members of the bench, we submit that the state has failed itself to conduct itself within the premise of that pronouncement by this court. Members of the bench, the proportionality test does not stop there. It goes ahead to ensure that whoever is limiting rights condones within themselves in the following three-part test. First, they have to pursue a legitimate aim. We submit, members of the bench, while national security is a legitimate aim, this does not in any way pass the second and the third test. They have to ensure that the measures used must be necessary. Paragraph 12 of the fact sheet, members of the bench, shows that the attacks were linked to infiltrators and not every refugee. Therefore, members of the bench, you cannot use a blanket justification of national security to limit the rights of all individuals from Zephyria, as there has been no proven individual culpability. To that we submit is a mockery to the constitutional provision that defined the order of this court, the history of this court in its pronouncement. In case that is not enough, honorable justices, we do wish to domesticate the case, the Canadian Supreme case of R versus Oaks, under the purview view of Article 2.6 and 2.5 to the Constitution, where the court in that judgment noted the three-part test that the state has to oblige with in limitation of rights. First, there must be a pressing and substantial objective to override the right. Note the wording of that submission, members of the bench. There must be a pressing and substantial objective. While national security may be termed as by the respondent to be a pressing and substantial objective, it does not pass the requirement that there must be a rational connection between the law and the objective. We cite, members of the bench, to cage individuals like birds, while others continue roaming free within our state, is not in any way providing a nexus between limitations of rights under Article 24 of the Constitution. Members of the bench, we further place reliance on Article 27(4) of the Constitution, where the wording in the limitations on the freedom of movement states that including to mean that those grounds for limiting rights has to be interpreted expansively and not restrictively. The state has to ensure the court has to ensure it places also attention to other matters derogating from an appeal. Members of the bench, we submit that the requirements in that case is analogous to the conditions the state has grounded our clients too. We submit that we have to holistically interpret that to ensure that we also put in accordance with exclusion and disadvantage effect of the encampment order. Members of the bench, we cannot sit here with the legality and the principles of our Constitution to ensure it is incumbent upon the state to promote and fulfill this right. We submit what they have done is unthinkable. What they have done goes beyond within the limitations of the rights. We submit, members of the bench, that such restriction has impaired the rights of individuals and has gone against the requirement of minimal impairment, that the state has to ensure it limits the rights as minimal as impossible. We submit that dignity, equality, freedom of movement and discrimination, all this has been indeed violated, and the principle of minimal impairment has not been fulfilled by the state in this case, members of the bench. In conclusion, honorable lordships and your lordship, we submit and pray that this honorable court allows this appeal and find that the Court of Appeal erred in the following four aspects. First, in upholding the use of AI without adequate human oversight, contrary to due process. Second, in finding no violation of the principle of non-refoulement, despite being a clear risk of persecution of individuals, including Warido and his family in Zephyria. Third, in disregarding the best interest of the child, contrary to Article 53(2) of the Constitution. Lastly, in failing to recognize that the state violated the principles that define our constitutional order, that is dignity, equality and freedom of movement. Members of the bench, we urge this honorable court to vindicate the promise that indeed even the most vulnerable individuals like Warido and his family deserve constitutional protection. Members of the bench, as if that is not enough, we wish this court to grant our client the following remedies. First, to compel the state to release all the individuals from the camp, as there has not been reasonable distinction or reasonable justification to limit their right from freedom of movement. Second, members of the bench, without prejudice, should this court find that indeed the respondent were well within the Constitution, it should compel the respondent to improve the conditions within the camp. That is to ensure that they provide adequate food and shelter, adequate housing, and they progressively realize socio-economic rights of Warido as they enjoy that protection under Article 43 of the Constitution. We further wish this court, considering the foregoing harm, we seek this court to compensate our client within the reasonable means of compensation. As the High Court of Nyota in the case of Musia versus Hornby Limited noted that it awarded the appellant the cash 1 million Kenyan shillings for just violation of the right to privacy. Members of the bench, in contrary, we see violation of dignity, violation of the freedom of movement, equality and freedom from discrimination. All these rights that define a living person worth of being called a human being being violated. As such, we submit, members of the bench, you should indeed notice that and award damages. You should indeed, members of the bench, in our conclusion, we see that we have 7 minutes left for us. We did wish to reserve that minutes in addition to any minutes that will be left for rebuttals in as such.
Thank you for your submissions and for keeping to the time allocated to you.
Of this court, my lords and ladies, good morning once again. As earlier introduced, my name is Tracy Jerop, appearing as the lead counsel for the respondents. With me today are my colleagues and friends, Mr. Liberty Mshindi and Ms. Ashley Ngeno. 15 minutes, I will be addressing the first and second issues on the use of artificial intelligence in refugee status determination. My colleague, Mr. Mshindi, will then step in for the next 10 minutes to address the third issue concerning the best interest of the child principle. And finally, Ms. Ashley Ngeno on orders. If it pleases this honorable court, I will now proceed to our arguments. Yet the facts reveal a very different picture. The state of Nyota, like many nations, faces the difficult task of we will invite this honorable. The actions of Nyota were informed by the best interests of both the child and the nation. The best interests of both the child and the nation. At the very onset, we acknowledge the jurisdiction of this court under Article 163(4)(a). Turning to the first issue of the Constitution, as well as the OAU and refugee conventions. Beginning with Article 47(1), we submit that the use of artificial intelligence was lawful, reasonable, and procedurally fair. This court in Suchan Investment versus Ministrated with full transparency, disclosing the data sources used, including biometric analysis, social media history, and behavioral pattern assessments for decision making. Therefore, by relying on transparent, data-driven assessments rather than subjective assumptions, the decision was lawful, reasonable, and procedurally fair. Moving on to Article 50, on the right to fair hearing, we submit that the right to fair hearing under Article 50 is broad and applies to judicial, quasi-judicial, and administrative contexts. While the appellant has argued that the right to fair hearing is non-derogable, we wish to clarify that what is in contention is not the right to fair trial, but rather the right to fair hearing. The Court of Appeal in JSC versus 2 justiciable elements. First, that an opportunity to be heard is provided, and second, that the opportunity is reasonable. To be heard was presented through the existence of an appellate mechanism. As seen, subject to the supervisory jurisdiction of the High Court. Subject to the supervisory jurisdiction of the High Court. This presented an opportunity for the appellant to challenge the AI decisions and even present evidence in their defense. While it may appear that the appeal mechanism, paragraph 4, paragraph 9, and paragraph 10 of the facts, where we find that the appellants were detained for this is the exact number of days that is provided for appeal under stated in paragraph 11 of the facts. The very final decision of deportation was not left to the AI system, but rather was made in accordance with the Refugee Act. This would mean that the decision was made by the Cabinet Secretary in line with Section 12 of the Refugee Act, thereby constituting further evidence of human accountability. Therefore, by ensuring transparency, human oversight, and accountability, the respondents upheld both the right to fair hearing and the right to fair administrative action. Finally, turning to the second issue, we submit that the deportation order was not in violation of the principle of non-refoulement. The appellants have asked this honorable court to view the actions of the respondent as a betrayal of the principle of non-refoulement. Yet, in truth, the actions of the respondent were not born out of cruelty, but of duty. A solemn duty to protect the life and security of millions within its borders. We ask this court to be persuaded by the Court of Appeal decision in Attorney General versus Kituo cha Sheria 2017, which held that Section 29 of the Refugee Act, read together with Article 33(2) of the Refugee Convention, foresees an exception to the principle of non-refoulement where the person poses a danger to the national security of the country. In the present case, the appellants constituted a danger to the national security of Nyota. This followed the discovery of digital footprints linking them to a designated terrorist group. In light of these digital links, the appellants exhibited a potential risk to the security of Nyota, which had recently experienced not one, not two, but 4 terrorist attacks which were connected to foreign elements exploiting refugee mobility. Additionally, this position aligns with the precautionary release 2023 at paragraph 46, which provides which provides that it is the duty of the state to take protective without having to wait until the reality and seriousness of those risks are fully materialized. In the present case, the respondent acted precisely within this duty. The AI RSD system identified digital footprints as a terrorist organization in Zephyria. While these digital links may not by themselves amount to direct participation in terrorist activities, they raised legitimate and credible security concerns that could not go ignored. Of civilian links materialized into actual violence would have been to neglect the state's constitutional duty to protect its people. Within this context, the decision to deport Warido and his family falls squarely within the exceptions under Article 33(2) and was therefore not in violation of the principle of non-refoulement. In any case, the appellant has argued that there existed a prima facie risk of persecution if returned to the 22, where the circumstances were factually similar. The European Court of Human Rights in this case held that the question of whether there exists a real risk of persecution must be assessed in light of the present day situation, especially where the deportation order is yet to be executed. In light of this, we draw attention to paragraph 11 of the facts, where we find that the deportation order was made in 2021. This is more than 4 years from the present day situation. Admit that the situation in Zephyria, moreover, the appellants have not discharged their burden of demonstrating a continuing or present risk in Zephyria, present risk of persecution in Zephyria, face targeted persecution of ongoing risk of persecution remains to be speculative. Ultimately, the deportation order does not violate the principle of non-refoulement. At this point, having concluded on the first and second issues, I will
Honorable Chief Justice, my lords, my lady, may it please this honorable court, good morning. As introduced earlier, my name is Liberty Mshindi, and in the next 10 minutes, I will substantively respond to the appellant's third claim. Contrary to what the appellants have submitted, we submit that the state's failure to conduct a best interest assessment for Warrido's children did not violate into the processes, making this process more efficient. It is therefore our submission that this did not violate Article 53(2) of the Constitution. To explain on this further, affirms this best interest of the child's right as a right of paramount importance in every matter concerning the child. The UNHCR guidelines, best interest of the child, under page 9, has stated that the best interest assessment is an evaluation done to each and every child to assess the individual right and determine whatever situation they are in. It is turning now to our second limb. I shall demonstrate how the state's use of the child has understood the best interest of the child to encompass three key concepts. First and third, that it is a rule of procedure. I will argue on the two principles that first, it is an interpretation. To begin, this regard, it is our submission that it was in the best interest of Warrido's children to be what you are experiencing. Therefore, the state of Nyota did not want to continue this propagation of torture and further trauma to these children. In that regard, we submit that as an interpretative principle, this rule was adhered to. On the formal determination of the best interest of the child, at page 3, my lords, the respondent submits that the AI system replicated this process through its design and operational architecture. On the most recent and verified information available, including changes in judgment on the child's best interest. Rather, it conducts an ongoing evaluation that mirrors the principle of continuous impact evaluation at each and every level. In that, we submit that as a rule of procedure, this right was met. It is with this that I now cede the floor to my co-counsel, Ms. Ashley Ngeno, to proceed with our arguments on the fourth claim. It has been an honor submitting before this court. Thank you.
Confinement of the appellant. I will then proceed to state our prayers before this court. My ladies, my lords, the respondent bears a heavy burden. We face a difficult challenge of balancing between the very delicate and sensitive matter of national security and the fundamental rights of vulnerable groups. This is no easy task, since these interests often pull into fundamental rights. They are subject to lawful limitation under Article 24 of the Constitution. This court, in the case of national security and fundamental rights, it imposed at the very onset the importance of this limitation is to enter seeking refuge, and this overwhelmed the available facilities. My ladies, my lords, this placed the respondent country. It was necessary to detain the appellant since they posed a risk to the national security of the country. And lastly, there is a connection between limiting this right to freedom of movement and pursuing the legitimate aim of national security. Therefore, we have established and have fulfilled the test of proportionality as set out by the appellant, and eventually we have struck a balance. I will persuasively rely on the European Court of Human Rights case of 2024 of BA versus Cyprus. In this case, we wish to distinguish the holding of this case and in this matter. The European Court noted that the detention becomes arbitrary if national security is cited and one fails to establish a link. But in this matter, we have established the link between limiting these rights and pursuing the legitimate aim of national security. Therefore, this detention cannot be claimed to be arbitrary. My ladies, my lords, the importance of this limitation is national security. There is a rational connection between limiting the right to dignity, the right to equality, and the right to freedom of movement, and pursuing the legitimate aim of national security. And lastly, the need to preserve their lives outweighs any restrictions imposed on community and business ties and businesses. Therefore, we have fulfilled the tests as stated earlier, and this limitation was reasonable and justifiable. The rise of technology and artificial intelligence is an inevitable reality that we must embrace sooner rather than later. It is important to recognize that difficult compromises may be necessary. However, even in these circumstances, the respondent consistently prioritized respect for human rights. The respondent has clearly demonstrated that the dawn of this new technological opportunity does not signal the dusk of human rights. Rather, it is an opportunity to show that we advance innovation while still upholding fundamental human rights. In light of these submissions, we ask this honorable court to dismiss the appeal. It has been an honor submitting before this honorable court. Thank you for your time. The respondents rest their case. I now cede the floor back to the court.
Thank you very much, counsel, for both the appellant and respondents for your submissions. I will give this opportunity now to the bench to ask you questions or seek clarifications on your cases. I will begin with the Honorable Lady Justice Kosopur to ask your questions.
Thank you very much. I have a question for Mr. Kariuki. So you said that the AI concluded that the family are terrorists, while in reality they were just opposing the acting government. So could you please clarify what terrorism or terrorist acts are, and could you also please clarify the difference between terrorist acts and freedom fighters acts or acts of political opinion? Thank you.
We will also give this opportunity to Justice Torres to ask our questions.
Thank you, Honorable Chief Justice. I'm also addressing this to the applicants. With respect to your argument on the best interests of the child, if you could kindly expound it on the perspective or angle of a do no harm principle. Thank you.
Thank you. And The opportunity now goes to Lady Justice de Klerk to seek your clarification or ask a question.
Thank you very much. It's also a question to the applicants. You were saying that the non-refoulement means that the state has to, if they go over to expelling somebody, has to look for an alternative. What rule are you basing on to say that? Thank you.
The Honorable Mr. Justice Ouko.
Thank you, my lady. To the appellants, Mr. Karaoke, you addressed this court, and I don't think I heard you invoke the provision of Nyota's constitution that allowed you to bring this appeal. Of course, I heard the respondents allude to the provision. Secondly, to the appellant again, it can be argued that the use of AI in this whole process was in consonance with Article 47 that requires the systems to be expeditious, efficient, and so on and so forth. To both sides, any of you can decide to answer this. You cited before us the apex court of Nyota, decisions of the High Court, of the Court of Appeal, of international tribunals. Of what value are these decisions, and how do you marry that with Section 3 of Nyota Supreme Court Act that requires it to develop rich jurisprudence based on its history and tradition? My lady, those are my questions.
Thank you. The Honorable Mr. Justice Renaura.
Thank you, Chief Justice. Thank you, Counsel, for your submissions. To Mr. Karaoke, if you look at question number one, issue number one, the question is whether the use of artificial intelligence also violated the 1951 Convention and the OAU Convention governing the aspect of refugee problems in Africa. You did not submit on that part at all. Would you like to tell us how use of AI violated those two conventions? To Mr. Mushindi, you made an interesting submission in my view. You said, and I hope I captured you right because I wrote it verbatim, you said best interest is unnecessary when AI is used. Would you like to clarify that for me? Thank you very much.
Thank you. I also have a question that I would like to direct to the respondents. I think any of you can answer. How is an asylum seeker meant to challenge AI decision if they do not even understand how it was reached? Secondly, I've also circled a question to you, the respondents, to explain whether there was any human involvement that was involved or that existed before you employed the use of AI. In other words, I want to know how the elements of empathy and connection could be discerned from the use of AI, especially when you are dealing with the vulnerable groups, children, especially children in this case. So, you've jotted down those questions. We will start with the appellants to respond to those questions. We will give you 10 minutes. Oh, one more question. Yes, from Justice Torres.
With your indulgence, Honorable Chief Justice, I'd like to propound one more question addressed to the respondents. You mentioned also, you discussed, and I was going through the facts of the case, that there is a prima facie danger of exposure, a prima facie danger of exposure to exposure to danger of the family if returned or deported. And as against the argument of a potential risk in terms of national security. Can you expound further with regard to the appreciation of evidence when you talk about prima facie evidence and when you talk about potential risk? How do you appreciate that? What is your quantum of evidence? Thank you.
Thank you, Justice Kosopuru.
Thank you, Chief Justice.
Thank you, Chief Justice. I have also a question for the respondent, Ms. Jerop. You said that the AI actually achieved that the assessment would be based on objective elements instead of substantive ones. Now, at the heart of the refugee determination is the fear, and there's also the subjective fear. Could you please elaborate a little bit on this, how the AI can make assessments of subjective fear, since, as you stated, no subjective elements were reviewed in this process? Thank you.
Thank you. Yes, Justice de Klerk.
Thank you, Chief Justice. It's a bit in the same line to the respondents. You said the use of artificial intelligence is in a way purer because it goes to the facts, and you cannot argue with facts. But then again, the idea of an oral hearing is to get facts in a context that you elaborate during a hearing. Does AI the same thing? And what AI is so complete that you can rely on it to do so? Thank you.
Yes, I think those are the questions and clarifications. My apologies. We will start with the respondents. We give you 10 minutes to respond to those questions and clarifications. Then we will come to the appellants to respond to the questions and also have another additional 10 minutes for you to respond to issues of law that arose out of the respondent's case. So we start with the respondents. You have your 10 minutes to answer your questions.
Honorable Chief Justice, my lords, my ladies, it is a pleasure to appear before you once more, and I will be answering my lord's question on what is the value of the subordinate court's decisions as well as the international law decisions. First, to answer your question, these decisions are persuasive before this court, and we rely on Article 163 of the Constitution, which states that they are only persuasive before this court. The value that they bring before the Supreme Court, given that the Supreme Court has to enrich its jurisprudence, is that it assists the court to come up with principles and guidelines in cases that are unique, which the Supreme Court has not faced before. It gives them it guides the court on certain principles to consider so as to establish and promote human rights, the rule of law, and democracy. Unless there are other clarifications? Thank you.
Yes. Are you sharing with your group, or you have somebody else from your group to answer?
The remaining questions will be answered by my co-counsel.
So you are sharing the time together?
Yes.
Your next counsel can come and answer the others.
Thank you.
Honorable Chief Justice, my lords, my lady, may it please this honorable court once more. I rise to answer my lords, Honorable Justice Lenaolo's question on whether the best interest assessment was unnecessary in this regard. It is the respondent's submission that due to the integrated AI system, that it integrated the real risks while rendering this process, the best interest assessment in this regard was rendered unnecessary in that the AI system conducted real-time data analysis, including evaluating changes in the country conditions. In that regard, we submit that the best interest assessment was not necessary. If the bench seeks no further clarifications, I would. Thank you.
How about the assessment of the child rights through AI? The assessment of the children through AI.
It is the respondent's submission that the assessment of the children through AI was efficient in that the AI system regarded the child's trauma that they had been subjected to in the Republic of Zephyria, and to not continue this trauma, the AI system rendered its decision, and the Minister for Homeland Security decided to maintain the familial unit so that not to propagate not to break the familial unit in that regard and further cause trauma to the children.
Thank you.
Thank you.
Honorable Chief Justice, my lord and ladies, it's an honor to appear before you once again, and in responding to the questions that have been posed by the honorable bench, I will begin by answering the first question. The first question on how is an asylum seeker expected to challenge the AI decision without understanding how it was reached. And in answering this question, we submit that the AI system in this case provided reasons for flagging Warido and his family as high risk. These reasons are espoused in paragraph 9 of the facts, where we find that the AI RSD system stated that the flagging of Warido and his family as high risk was dependent on digital footprints linking them to the Democratic Liberation Party, which was formerly designated as a terrorist organization in Nyota. Additionally, the appeal mechanism would provide an opportunity to explore these reasons further, with the appellants getting a chance to even provide evidence in their defense. Additionally, in responding to the second question on whether there was any human involvement employed in the use of AI, we submit that there are 3 instances where we see the employment of human oversight. The first is before the declaration of Warido and his family as high risk, where we note that the AI systems are usually trained on data, and this is done by human beings. The second instance is through the existence of an appellate mechanism to a specialized tribunal, which would allow the appellants to challenge the decision that was reached and present evidence in that regard. And finally, in paragraph 11 of the facts, we find that the AI system did not constitute the very final decision of deportation, where we find that the decision was reached in accordance with the Refugee Act, which would mean that it was made by the Cabinet Secretary in line with Section 12 of the Refugee Act. This constitutes further evidence of human oversight throughout the process. In answering the third question that was posed by my lady on how to balance potential risk vis-a-vis prima facie evidence of risk if returned to Zephyria, we wish to clarify that in paragraph 11 of the facts, as rightly noted by my lady, there is evidence of prima facie evidence of exposure to danger if returned to Zephyria. However, while we note this concern, we submit that we ask this court to be persuaded by the case of TK versus Lithuania, where the court held that the relevant time in terms of assessing whether or not there exists a real risk of persecution is during the ongoing proceedings. And given that the deportation order is yet to be executed and was made in 2021, more than 4 years from the present day situation, we ask this court to find that the appellants have not adduced any evidence as to the existence of continuing persecution of DLP members in the state of Zephyria. And given this, any claim of prima facie risk of persecution if returned to Zephyria remains speculative. In answering the two final questions that were posed by my ladies, I ask that you allow me to answer the questions together, as the first question touches on whether the AI can make assumptions as to subjective fears, while the second question touches on whether how the AI integrated facts. And in answering both these questions, we submit that, as outlined in paragraph 8 of the facts, the AI RSD system relied on various factors including behavioral pattern assessments. We wish to bring it to the attention of this honorable bench that behavioral pattern assessments can take various forms, including but not limited to questionnaires and even video recording. We ask this court to therefore find that in the case that the AI system, given the state of Nyota as a champion of human rights, we ask this court to then reasonably infer that this behavioral pattern assessments could have included the inclusion of video recordings, and in doing so, should the AI have been used to then assess this video recordings, it would have collected not only objective data, but in observing the mannerisms of the refugees in questions, could have assessed the manner of their being, maybe even their answer to questions, and in employing the use of objective data, would be able to then look into their subjective fears and make inferences as to whether or not they were lying, whether or not their claims were credible. Given this, my lord and ladies, having answered all the questions that were posed by the bench, I will now cede the floor back to the bench. It has been an honor submitting before this honorable court. Thank you.
Now the appellants have the opportunity to respond to the questions. You have 10 minutes to do the responses, and then we'll give you another 10 minutes to respond to points of law that arose from the submissions of the respondents.
Much obliged once again. A question was posted by the learned Lordship Ouko on the applicability and the standing of international law and how they align with Section 3 of the Supreme Court Act. To that we submit, this court was faced with a similar question in Mitubel Welfare Society versus Kenya Airports Authority to note what was the effect of Article 2.5 and Article 2.6 of the Constitution of Kenya, especially on applicability and practicality of international law, in particular to human rights. And this court noted that it was both inward-looking and outward-looking. It was outward-looking in the sense that they committed our state to conduct itself in relation and in accordance to our international obligation under international humanitarian law. And secondly, they were inward looking in the sense that the courts in Nyota need to apply international law in resolving disputes before them, as long as they do not contradict the Constitution, the local statutes, and even judicial pronouncements. They were also used to ensure they apply to fill the legal lacuna that our state is experiencing, especially matters raised under this court. Some of them are experiencing novelty. We can see principles of non-refoulement. The use of AI are new matters within our jurisprudence, and therefore this court has an opportunity to fill that legal lacuna.
Much obliged. The appellants did take note of your concern. Your Lady, Honorable Justice Torres, asked a question on the do no harm principle. The appellant will answer your question in reliance to the case of AOO versus Attorney General, which stated that children are the most vulnerable within the society and they require special protection. This clearly gives states an obligation to make sure to protect children from any sort of harm. And this is why the High Court in the case of Refugee Consortium of Kenya versus Attorney General in the year of 2015 in paragraph 20 of the judgment went on further to state that children require, or in order to come up with the best interest of the child, there needs to be determination and an individualized, clear, and comprehensive examination of the real-life situations of the child. We would also like to rely on the United Nations High Commission on Refugees guidelines in paragraph 15 that states, while children may face similar or identical forms of persecution as adults, they may experience them differently. Actions or threats that might not amount to persecution in the case of an adult may amount to persecution in the case of a child. In this present case, in paragraph 11 of the case facts, no individualized assessment was conducted for the children. And in paragraph 3 of the case facts, it is clear that these children face mass atrocities, mass execution, sexual violence targeting women and girls. We also submit before this honorable court, and to answer also your question, that in this particular case, the respondents evaded and disregarded this particular principle and did not consider children as the softest pages in which humanity is written. I would like now to cede the floor to my co-counsel to answer the next question. Much obliged.
Greetings once more, honorable members of the bench. As earlier introduced, my name is Cyrus, here to respond to the questions posed by the bench. I'll begin by responding to your ladyship's question on the AIRSD and terrorism. We did not submit that Warido and his family are indeed a terrorist group. We submitted that they are not, and that the respondents, pursuant to paragraph 196 of the UNHCR Handbook on Procedures and Criteria for Refugee Status Determination, did not ascertain the facts, members of the bench, to confirm that indeed they were not, and that they simply belong to an opposition political party. To respond to your question on the definition of terrorism, allow me to place reliance on the Organization of African Unity Convention on the Prevention and Combating of Terrorism, where under Article 3 defines terrorism as acts which are in violation of the criminal laws of a state and which endanger the physical integrity and which also endanger the life or cause injury to persons. Furthermore, allow me to place reliance on the United Nations Security Council Resolution 1566 of 2004, where they acknowledge that terrorist acts or terrorism is indiscriminate and may target a whole population or part of a population in a region. The respondents did not conduct an investigation to ascertain this, the parts that I have mentioned, that Warido was a danger to the criminal laws, or rather violated the criminal laws of his country, or whether Warrido and his family targeted or rather conducted terrorist attacks. To respond to the question that was posed by our submissions with regards to alternatives to the principle of non-refoulement, we allow us to place reliance on the International Detention Coalition Captured Childhood Report, particularly Chapter 6, where the court, or rather in that report, proposals are issued with regards to the principle of non-refoulement and national security when the two are at play. It proposes that states should try to take refugees or asylum seekers to other regions or to other states where they are not a risk to the national security of that state. Furthermore, we submit that Warrido and his family should have been detained in the state of Nyota to prevent them from being persecuted back in their state, as opposed to refouling them back to their state, considering that they faced persecution and danger. To respond to the question from the learned judge's question on jurisdiction, Your Lordship, Justice Oko, you had a concern with regards to jurisdiction. We indeed do not wish to contest jurisdiction, seeing that it is not in contention pursuant to the fact pattern. However, to respond to your question, we place reliance on Article 163, sub-Article 4A of the Constitution of Nyota, which provides that appeals from or lying from the Court of Appeal are subject to the jurisdiction of this court if they involve issues of interpretation and application of the Constitution. And this has been affirmed by this Honorable Court in Benson, Ambuti, Adega, and 2 others, versus Kibos Distillers Limited and 5 others, petition number 3 of 2020, where the court indeed emphasized that if issues involve interpretation and application of the Constitution, then the court does indeed have jurisdiction. To respond to the question on the AIRSD and Article 47, and on the fact that it promotes expeditiousness, we do not contest that fact. It does indeed provide expeditious administrative access, human oversight in refugee status application decisions, as well as paragraph 205 of the one, where under paragraph 1, international law, or rather United Nations guidelines, may be relied on by this court to breathe life into Article 20 of African Unity, allow us to place reliance on the African Commission on Human and People's Rights versus Libya application number there to procedure should be condemned by this honorable court, honorable members of the bench, and therefore in that way and in that sense I have indeed addressed.
May it please these responses to the respondent submissions. On the first council's of the fair administrative actions that include lawfulness and procedural requirements. Fairness, for example, the state did not give written reasons, notice of an appeal, or review that violates the right to fair hearing. To also answer the first council's submission as the respondent on the principle of non-refoulement, we submit before this honorable also did not conduct an investigation to ascertain that these facts, as obligated under paragraph 196 and paragraph 205 of the United Nations High Commissioner for Refugees Handbook on Procedures and Criteria for Refugee Status Determination, which obligates on the formal determination by the respondent. However, to answer this question, we submit before this honorable court in reliance to no excuse not to uphold the best interests of the child and to cater for the children's rights that are outlined under the Children's Act. I would like now to cede the floor to my co-counsel who will also respond to the respondent submission. Much obliged.
In their precision, they relied on Haki na Sheria Initiative versus Inspector General, noting that the curfew order was reasonable and in line with the discriminatory. In the case before you today, the encampment order is being only applied to individuals from Zephyria, and therefore the reliance of the respondent on Haki na Sheria initiative versus Inspector General is flawed. Of Lady Justice Martha Koome, speaking in her capacity as the chairperson, chair lady of the National Council on the Administrative of Justice. She led the council in administering and releasing a powerful communique in ensuring that in addressing the ongoing civil unrest, addressing the policy concerns, the policy implementers need to ensure they preserve the peace and the constitutional order that define our constitutional integrity, in particular the respect to human dignity as it is a pillar to other constitutional rights. She further emphasized in that communique that institutions must carry out their mandate in accordance to professionalism and utmost proportionality, and it is our submission that indeed the respondent have failed to substantiate the same. You are invited also, members of the bench, to note there was an influx of refugees in our state. To that we submit in reliance to Satros Ayuma case versus Attorney General, where the court emphasized that lack of resources cannot be used as a defense to indignity. The state has to ensure it provides the basic core humanitarian conditions. That involves respect to dignity, survival, and the need to ensure every individual is treated as worth of being called a human. To subject our clients into conditions that are unsanitary, and even the conditions are overcrowded, members of the bench, we submit that is a mockery to the Constitution of Nyota and should not be blessed by this court. Members of the bench, you are also, in other words, the respondent's case pillar was on national security as the reason for blatantly disregarding the rights of refugee. Members of the bench, Article 24 of the Constitution allows limitations to the extent that is reasonable and justifiable in an open and democratic society. We submit, members of the bench, what we see here is not a limitation. It's the guise of national security to ensure they blatantly disregard the constitutional rights provided for under Nyota. Members of the bench, in the case of Katiba Institute versus President of Kenya and others in 2021, the court emphasized that security concerns cannot be used as a blanket justification for curtailing various importance of national constitutional rights. And long gone are the days when national security used to be applied in a blanket manner. And this court should indeed note that there has been no reasonable distinction between the blatant disregard of the rights of refugees and the protection of individual rights of national security, as it is the obligation of the state. In case that is not enough, members of the bench, this court noted in Law Society of Kenya versus Cabinet Secretary, Ministry of Health in 2020, the COVID-19 curfew case taught us the importance of maintaining reasonable conditions on restricting rights. And to that, members of the bench, we submit the respondent cannot use urgency to curtail rights in an unreasonable manner. Members of the bench, you are also invited to ensure that you place a reasonable distinction between discrimination of the rights and national security. To that we submit it was a flaw invitation. As such, members of the bench, the Court of Appeal in Mohammed Fugicha versus Methodist Church in Kenya, in its persuasive nature, the court emphasized that even if direct discrimination or indirect discrimination has no explicit harmful intent, its effect, including exclusion and disadvantage, can lead to discrimination. And to that we have submitted, and as earlier submitted,
I really want to acknowledge the presence of our visiting justices, Justice de Klerk, Justice Kausoporu, and Justice Maria Torres for joining us this morning. I also want to recognize our distinguished deans of the law schools, the team coaches of the various law schools, to appreciate in a very, very special way the participants of this second Supreme Court Moot Court competition, to appreciate our registrar, deputy registrars, law clerks, the distinguished ladies and gentlemen this morning. On behalf of the bench, I want to thank also the organizers of the 14th World Conference, International Association of Refugee and Migration Judges, led by the Honorable Mr. Justice Renaura, for giving us this opportunity to hold this second Moot Court at the fringes of the international conference that is sharpening their skills in advocacy. So as you have said, dedication, diligence, and passion, the clarity of your reasoning and the sophistication, the clarity of your reasoning and the sophistication of your advocacy. To craft very persuasive arguments and to respond with agility during your oral submission, submissions. These are very essential skills to pursue. We will be now addressing the two finalist teams as we await to render our judgment. What we want to say on the preliminary is that you have stood out among a highly talented pool of competitors. And behind this competition, but in your future careers as advocates, scholars, judges, or international jurists. It is not every day that law students stand before the honorable justices of the government will ignite within you a deeper appreciation of judicial processes and inspire you to aspire to the highest standards of professionalism and service. This competition forms part of the. Through this initiative, we seek to demystify the court. We seek to cultivate young legal minds of forced displacement, migration, and the protection of refugees, which are very, very defining issues at the moment we are at globally. At the same time, artificial intelligence is shaping emerging technological, humanitarian, and ethical challenges. Participant in this competition is already a winner, made in you, and you have brought of our legal profession. Watching your energy, your talent, imagination over the last 3 days fills us as justices seated on this bench and Supreme Court and the entire judiciary with confidence